Good afternoon. Thank you very much for joining us today. My name is Dawn Clark. I'm the Lettings and Property Management Director at Nock Deighton. I'm presenting today this webinar just to update you on the Renters' Rights Bill. Obviously, this hasn't come into effect yet, but it is currently going through Parliament, and we have a lot of landlords who are asking about what's going to happen, what the Renters' Rights Bill includes. So we're going to just give you a brief overview today as to what the main points are and what this means to landlords. So, as a brief introduction, going right the way back to 1988 Housing Act, this introduced assured short-hold tenancies. So prior to that were assured tenancies, and if a landlord rented a property out, if a person rented a property out, they would have a long-term tenancy. And so this introduced the Section 21 notice, whereby a landlord could serve a 2-month notice on a tenant without giving a ground, without citing a ground, just to end their tenancy and get the property back. So this became law in 1988. This also brought about many accidental landlords, what we call accidental landlords, which were landlords who, for whatever reason, didn't want to sell the property or couldn't sell the property and needed to move into another area, for instance, with their job. They were then able to rent their property out short term for 6 months, 2 years, however long, and still serve a Section 21 notice at the end in order to gain possession of their properties. So it just made it a lot easier for people to rent their properties out without having what they called a sitting tenant. This then encouraged investors to invest in property. So this brought about the buy-to-let market. Since then, we've had many people that have invested in property over the years, and has made us sort of what we do now, and has generated a lot of sort of income for investors, rather than put the money into pensions, or as well as putting money into pensions, and so it's generated a supply for a huge demand of rented property that we have in the market today. Over the years, more and more legislation has come into place, obviously because buy-to-let market has grown. So governments have needed to bring legislation in order to protect tenants and in order to make properties safer. So obviously we've had the gas regulations and electrical regulations and everything to make sure that rented properties are safe. But also the Housing Act, many more Housing Acts have sort of come into effect since then. Then the Deregulation Act, the Tenant Fees Act, and so on and so forth. So all that has sort of happened over the last sort of 30 years. Jumping right the way forward to 2019, you may remember our late Queen's speech, who first introduced the Renters Reform Bill. This was as a result of, I think, Shelter being the main charity who were campaigning for years in order to bring legislation in to abolish the Section 21 notice. So this is when it was first introduced within the Queen's speech, and when the Renters Reform Bill was first sort of became public. Again, jumping forward another sort of 4 or 5 years, now the Labour government have come into effect and introduced more or less a carbon copy of that Renters Reform Bill and called it the Renters' Rights Bill. Whereby it's there's a few sort of tweaks and changes to it, but the main points that were introduced in that Renters Reform Bill will still come into effect. Just giving you a few statistics here. The number of private rented households in England in year 2000 was 2.03 million. In 2017, that had gone up to 4.69 million rented households in the UK. And then the last records that we're able to obtain were 2023, where that number had dropped down slightly to 4.6 million we are finding that that obviously because of all the changes, then many landlords are exiting the market. Not that we want that to happen. In 2023, there was an article released by the BBC reporting the number of houses available to rent in the UK had dropped by 1/3. That is absolutely the case. We're finding that because we're getting so many inquiries for each property that we release, it's very difficult now for renters to find a suitable property. They're being pipped to the post by others, or we're finding that we're having sort of over 30 inquiries for each property that we certainly have available, and it's very, very difficult for people to just find a suitable property and move into it. So going back to why we're here, the Renters' Rights Bill, the proposed outcome that this new legislation is supposed to bring in is a fairer and more transparent rental market. It's supposed to provide increased security and more stability, better living conditions, obviously, for tenants, and more power to challenge unfair practices. This, again, it's all as a result of many unscrupulous and rogue landlords who have rented properties out, not so much around here, but again, many in London who have taken advantage of renters and tenants. And so this is another reason that this legislation is coming into force. Excuse me. So I've got a little table here on how the Renters' Rights Bill is different to the Renters' Reform Bill. So the main points: abolishing Section 21, expanding the grounds for possession, decent home standards, limiting rent increases, and prohibiting discrimination. They're all still the same. What the Renters' Rights Bill is also proposing to introduce is a landlord ombudsman. This is to sort of shortcut court cases, really. So you've got an ombudsman there that is able to sort of listen to and settle disputes. Banning on rental bidding wars. I'll go more into this one in a little while. Creating a private rented sector database where landlords and agents must register, and strengthening the enforcement of non-compliance. So we'll go a little bit more into that shortly. Abolishing fixed-term tenancies. So when the bill is introduced, there will no longer be fixed-term tenancies. At the moment, most of the tenancies we set up are 12-month fixed-term assured short-hold tenancies. There will no longer be any fixed terms. All new tenancies will be periodic right from the outset, and when the bill comes into law, all existing tenancies will become periodic overnight. So this will mean that if you're currently in a fixed term tenancy, even if it's for 2 years and doesn't end for another 2 years, from when that bill is introduced and when it becomes law, it will be a periodic tenancy, which means that the tenant can serve notice. How will this affect you? The one change that is a slightly positive change here is that tenants will need to give 2 months notice. At the moment, under tenancy law, a tenant doesn't actually have to give notice. Most tenancy agreements will state that they must give at least 1 month's notice. But this new legislation is stating that tenants will need to give 2 months' notice to end a tenancy, and also that the end of the tenancy will need to align with the end of a rental period. So in practice, this will mean if a tenancy starts on day 1, say on the 1st of March, a tenant can give notice on day 2. It will need to be 2 months' notice. So it will need to align with the end of a rental period. So rent will be paid monthly. So if it's the 1st of March, it will be the end of May that a tenancy will end. So effectively, it will be 3 months. It will be the shortest tenancy that will be allowed. So the one good thing is that if they're giving 2 months notice, if you want to relet the property, you will be able to, you'll have 2 months in which to do that. And providing your tenant allows access, then that will be plenty of time in order to find another suitable tenant and rearrange another tenancy. So void periods should be at a minimum because of this. Abolishing Section 21 evictions. This is the main sort of headline, really. Landlords will no longer be able to serve Section 21 no-fault notices to regain possession of their properties. How will this affect you? So, you must have reasons for serving Section 21. Basically, at the moment, a landlord can say they don't have to give a reason. Here's 2 months' notice, and you must leave. If the tenant doesn't leave, you can go to court. You haven't got to cite a reason. You can say I've served my Section 21, providing every I is dotted and every T is crossed. The court will grant possession. So you must again have a reason when the new legislation comes into effect. One of those reasons will be if a landlord wants to sell a property. So you will still be able to do that. Or if a landlord wants to move into a property or move a member of their family into the property, again, you will be able to serve a notice in order to do that. If a tenant is in breach of tenancy, if it's a mandatory ground or if it's good enough discretionary ground, you will be able to get possession of your property. For instance, if a tenant is in rent arrears, you will be able to do that. So if a tenant isn't suitable, we've got to look at why a tenant isn't suitable. So if they're not maintaining their garden, that's not going to be a good enough reason to end a tenancy. If they're not parking in the correct place, again, it's mediation will be what's needed in this case, not just serving Section 21. And this is what they're encouraging, is that the no-fault evictions must come to an end. So if it's a ground which comes under a discretionary ground, then it will be up to a judge to grant possession. So you've got to think about why isn't your tenant suitable for the property, and so they're just again trying to just make sure, legislate these reasons for possession. Expanding Section 8 possession grounds. So here, Section 8 notices will be the only way that landlords will be able to evict tenants. There are currently, since the 1988 Housing Act came into effect, there are mandatory and discretionary grounds for eviction. They will still be in place. There will be strengthened grounds here, as we said, for if a landlord wants to sell or move a tenant into a property. I've just said that one. And there will be a new mandatory ground for repeated serious arrears, whereby if a tenant is 2 months in arrears with more than 3 times within a 3-year period, then that will be a ground for actually gaining possession of the property. So if they are persistently late with their rent, that's one thing, but if they actually get 2 months in arrears at 3 times or more within a period of 3 years, then that will be a mandatory ground for possession. So again, I have to stress here, keep accurate records of any rent arrears. If the tenant is late, make sure you've got a record of you contacting the tenant and chasing the rent as well, but also the date that it is paid. Make sure you're keeping those records of the dates of the payments, because if you do need to get possession of a property for this under this ground, you'll need to make sure you've got those records and that they're accurate. Also, under the Section 8 possession grounds, all 14-day notice periods will be doubled to 4 weeks. So again, this is something that they're changing, and rent arrears will need to be 13 weeks before serving a Section 8 notice. So at the moment, rent arrears have to be 2 months before you can serve a Section 8 notice to start possession proceedings. They will need to be 13 weeks in arrears before serving Section 8 notice. Again, I'll talk about rent guarantee insurance later. This is one of the reasons that you need to get rent guarantee insurance. On more grounds, all 2-month notices will become 4-month notices. So, for instance, at the moment, Section 21 notice is a 2-month notice. With the new grounds, if it's for gaining possession because of you want to sell the property, or you want to move into the property, move back into the property, again, that notice will now be 4 months notice. Holiday let ground will be abolished at the moment under current legislation. This is a ground for possession where if the property was previously let as a holiday let and you need to let it again as a holiday let, you would be able to get possession for this reason. This will no longer be the case. This one's being abolished. And there will be a new mandatory ground for antisocial behaviour and rioting, whereby that notice period will actually be reduced to 2 weeks. So again, you've got to make sure you've got your evidence there and keeping your records there as well. There will also be changes to abandonment provisions. This is a little bit, well, currently the abandonment provisions, they change quite often. And they're a little bit woolly, so we're hoping that with this new legislation that's introduced, there will be some clear and concise rules about this. A limit to rent increases. So Section 13 notices will be the only way for landlords to increase the rent. At the moment, landlords can increase the rent at the end of a tenancy by proposing a new tenancy. All rent increases must be via a Section 13 notice. A rent increase can only be served once a year. So again, if landlords have increased the rent more than once a year previously, they will no longer be able to do this. Not standard practice, really. There will be a ban on rental bidding wars, so landlords and agents will not be able to accept offers above the advertised price. This isn't something that happens a lot in this area. We generally find that if we put a figure on a rental property, that will generate enough interest, but we don't have tenants or people that want to pay, that are happy to pay more. We don't encourage any offers above the advertised price. But it does happen quite a lot, we are told, in London and down south. But also here, we will not be able to accept any advance rental payment above 1 month's rent. That's another part that they're introducing in the legislation. So sometimes we get a tenant who is happy to pay 6 months or 12 months rent in advance in order sometimes to sort of jump the queue if they've got sort of that capital there. And again, this is another reason that they're bringing this in to stop people from jumping the queue. Unfortunately, that will actually be a disadvantage in some cases, because we quite often get people who have been living overseas for a number of years coming back into the country, but they haven't got any credit history because they've been away, and they're able to rent sometimes if they make an advance rental payment, which helps them sort of get back in and settle back into the UK. The government haven't thought about this, and I know that a lot of people and landlords and agents and people have been sort of trying to make that clear. There are other reasons that tenants sometimes want to pay 6 or 12 months rent in advance in order to secure a tenancy, but this won't be allowed to happen under the new laws. Rent controls. They did reject the calls to introduce rent controls, thankfully, so that will not be happening. However, tenants will have the right to challenge rent increases that they believe are unreasonable or above market rate. So if you've got if a property is advertised way above anything else, then a tenant will be able to sort of challenge that. Or also when they're in a property and if a landlord wants to increase the rent in order to maybe try and sort of get possession of the property, they will have the right to challenge that in a sort of tribunal process. But providing the rent is market level, and you can produce evidence to show that it is market level, then that challenge will be sort of thrown out. But again, this is to stop landlords from charging too much rent. Creating a private rented sector database. So this is due to be a digital database, and it's designed to compile information about landlords and properties and provide visibility on compliance. All landlords and managing agents will have to register on this database, and they will also need to register, as well as their name, their address and their contact details, they will have to register the property or properties that they have, and each of their properties will need to be listed upon this database. We've had a lot of worry about this from our landlords. I know with regards to sort of data protection, people have asked, well, you know, I don't want all my information displayed for the public to see how many properties I have. I'm sure there will be some, well, we know that there will be compliance with Data Protection Act here, and there will be some restrictions really on what you can and cannot use. But the purpose of this is to make sure that any enforcement action taken against landlords and agents is listed and is visible for people to see as well. Again, it's just the main purpose is one, so that the government can keep details of landlords, of course, but also to cut out the rogue landlords. Fees will be payable, of course, in order to register the property or to register on the database. We don't have the finer details as to what the fees will be, whether the fees will be per landlord or per property. I expect it will be per property, but we don't know yet. A landlord ombudsman. So this will be a new introduction as part of the new law, and the landlord ombudsman will be to help resolve disputes between landlords and tenants without the need for court involvement, because as we know, the courts are completely overloaded at the moment. So this will help resolve disputes without having to go to court. Tenants can raise complaints regarding property standards or unresolved repairs. Again, if you're a good landlord and you carry out the necessary repairs, this should not be a major issue for you. The Ombudsman will be funded from the landlord database fees. Decent home standard. So all rental properties must meet a minimum quality standard. And be in a reasonable state of repair. There will be you must provide reasonably modern facilities and services within a property, and a reasonable degree of thermal comfort, so heating and ventilation, of course, and meet statutory minimum fitness standards. So we're not expected as landlords to make sure you've got new kitchens and bathrooms and things like that. You haven't got to provide a sort of a new property each time you let it out. This really relates to properties on the other end of the scale, which are in really poor condition, and again to sort of protect tenants. And also to apply the AWAB's law will be applied here, which as a result of that terrible property that caused a death of that little boy just a few years ago. So landlords must follow strict timescales to inspect and repair hazards such as damp and mould. I know we come across a lot of cases in properties where we know it's due to tenant living conditions. Sometimes it's the property, the construction of the property, which might produce more condensation than others. So again, it's a very grey area at the moment, but what we do know is that if a tenant does report a hazard, if they do report mould in a property, it does need to be investigated and it does need to be dealt with. So as long as we know it's just a lot of mould is just due to condensation, which is as a result of inadequate heat and ventilation, and that sort of changes can be made in order to make those conditions better, and also to educate tenants as well on ventilating properties and things like that. So it's something that we sort of get quite involved with as agents. But again, make sure that something doesn't get sort of gradually worse and is not attended to. The new laws will introduce a point to prohibit discrimination, whereby landlords cannot refuse tenants on benefits. It doesn't happen very often, but sometimes a landlord might ask whether they can state no housing benefit. This is really only because of the uncertainty in most cases of the income. Whereas what we do when we look at, I mean, obviously we consider any tenants for any properties, and we always make sure we've got a standard procedure for checking the income. So if a tenant is on receipt of benefits, they should be allowed to apply for any property, and what we do is we make sure that they have sufficient documentation and proof of the income of the benefits that they're currently receiving or that they are entitled to receive, to make sure that the income is there and the affordability is there. So a landlord will not be able to state that they will not rent a property out just because a tenant is on benefits. And also landlords cannot refuse tenants with children. Again, there are some laws in place which relate to HMOs, houses of multiple occupation, whereby there's a minimum size for rooms for occupancy of the number of people that are living there and number of children. Those will be able to sort of refer to those sort of sizes of properties when it comes to sort of smaller properties and the number of people that are applying. But again, a landlord will no longer be able to just basically state they don't want children in a property. Tenants' rights to request a pet. Tenants will have the right to request a pet both before and during a tenancy when this new legislation comes into effect. A lot of landlords at the moment state that they do not want tenants with pets, and they're able to state that from the outset. This will no longer be the case. They need to have a legitimate reason for refusing a pet, and if they've had a bad experience and don't want to have a pet again, this will not be a valid reason. One reason might be because if it's a flat, if it's a leasehold property, and the terms of the head lease state that that no pets are allowed in the building, that would be a legitimate reason. Or I think when we've been sort of watching or speaking to sort of other agents and other landlords, sometimes a landlord might state that they have a pet allergy and they need to move back into the property at some point. Again, that might be a legitimate reason if you can actually provide proof of that. But again, you would need to have the documentation there. What you've got to think of is if you were standing in front of a judge or in front of an ombudsman and stating the reason that you would not want a pet in a property, or the reason that you've refused a pet in a property, what would that ombudsman think? What would the judge say at the end of the day? So just sort of put yourself in that scenario. If it's a legitimate reason, then that's fair enough. As we said, landlords must consider and cannot unreasonably refuse a tenant's request. However, landlords and agents can request pet insurance to cover potential damage from pets if needed. Insurance companies are in the process of bringing out new policies. We don't know whether that's all they're going to be landlord policies or tenant policies. But just going back to prior to 2019, if a tenant had a pet in a property, then a landlord could say, well, they wanted a higher deposit in order to cover any excess damage that might be caused by that pet. The Tenant Fees Act 2019 outlawed that because deposits were fixed at 5 weeks' rent. So since then, we know that a landlord can ask for a higher rent, providing it's marketed in that way to start with. They can ask for a higher rent if a tenant has a pet, in order again to cover additional wear and tear on the property, for instance. So what this new legislation is going to introduce, and what the insurance companies are introducing, is a pet insurance. So this would probably be as an alternative to a higher rent if a tenant has a pet. So if a landlord might be able to will be able to state that yes, they will allow a tenant to have a pet in a property, providing the tenant can prove that they have insurance, or providing the tenant covers the costs of their insurance. So again, that will be we'll get more information on that one as and when the legislation is released fully. But insurance is definitely. So implementation, when is all this going to happen? First reading was in the House of Lords was on the 15th of January this year. The second reading was last week on the 4th of February. Then you've got the committee report and the third reading stages in the House of Lords. That's still due to happen. Following that, the government will consider the amendments that have been proposed, and it will then go through to royal assent. Once the royal assent has taken place, it's likely to become law within 2 months. But what they're stating is that parts are expected to become law by the end of spring 2025, and other parts may be staggered or delayed. Again, this is speculation at the moment. We don't have any sort of further information, but the one thing is fairly certain is that it will come into effect this year, and could be as early as sort of the end of spring, early summer. So, in summary, many landlords have exited the market over the last few years. Various reasons could be due to Section 24, which was the end of tax relief for mortgage interest payments. Obviously, since the pandemic, we've had many increases in interest rates, which has made a huge difference to the return on investment. We've had landlords that have exited because they want to release their capital. They've had the property for a number of years, or the properties for a number of years, want to reinvest or go off on a cruise and retire. So there's many reasons why landlords have exited the market. And again, it could be that this is the final straw when it comes to sort of legislation. What we are certain of is that there is an overwhelming demand for rental accommodation, certainly, well, throughout the UK, but certainly in the areas that we deal with in Shropshire and Worcestershire. And I can't see that changing. The government has pledged to build more properties, as they have done, but they will have to build a lot of properties very, very quickly in order to go anywhere near to meeting the demand for rental properties throughout the UK. So there's one thing is for certain, is that you should never find an empty property. You will never have a property that without a tenant in situ, or without interest in it, if it's a good property. So our mantra is good landlords who create good properties will lead to happy tenants. Fairly simple, but at the end of the day, that's sort of what we work on. We manage a lot of properties, and for a lot of good landlords who maintain their properties, provide happy tenants who have been in there for a number of years, and we want that to continue. We need that to continue in order to sort of generate again, try and help sort of meet the demand. And our best advice for landlords, for existing landlords, for new landlords, investors, is to prepare ahead. Make sure you've got a good tenant selection procedure and you get good references for your tenants, because obviously you want long-term tenants, so you need to make sure that they're going to be good tenants. We have very strict referencing procedures in place. We get previous landlord reference, we get obviously proof of current income. We do full credit searches on every applicant that is applying for a property, and so we're making sure that we've got a very robust referencing system in place. Tenancy agreements, make sure you've got a good tenancy agreement. As far as we're concerned, all of our tenancy agreements are approved by or provided by Arla Property Mark. We're members of Arla Property Mark, so as soon as the new legislation comes into effect, they will be providing new tenancy agreements to ensure that landlords are fully compliant, and we'll be able to provide those tenancy agreements again for all of our clients. Rent guarantee and legal protection insurance. I cannot stress and recommend this enough. Whether you get it yourself or whether you do it through your agent, it is an absolute no-brainer now with regards to when it comes to sort of notices being extended to sort of from 2 months to 4 months, and making sure that you've sort of got that cover in place, so that if there's any rent arrears for whatever reason, or that you have to go down the route of getting legal possession, then your costs are covered. 4 months is a long time without any rent, and obviously court costs can be sort of over £2,000 now. So having legal protection in place and rent guarantee is absolutely paramount now with this new legislation coming into effect. And finally, make sure you've got accurate records. Making sure that if you are corresponding with your tenants, keep any copies of emails, keep records of everything that you're doing, of work that you're carrying out, of attempts to get access to a property, because sometimes contractors can't get access. Make sure you're keeping all those accurate records of everything that you do. Put it all in writing, confirm everything in writing as you can, and keep it there safe, so that you've got that if worst case scenario happens. It's the case now, and going forward, it's more important as well. Keeping accurate records of of rents, whether you've got it, whether it's through your agent or if you're doing it yourself. Keeping some spreadsheets available of income and expenditure and times that dates that rents are being paid, etc., etc. So again, make sure you've got those accurate records. And moving on just to my final slide, just like to mention that we do now offer extended services. We have been up until recently offering two levels of service. We're now extending that to 4 levels of service. We're offering a bronze let-only service to landlords who are happy to manage their properties, their portfolios themselves. Our let-only service is starting at a fee of £500 plus VAT, and you can add additional things onto there as you require. Our silver service is something that we offer at the moment. This is our sort of letting and rent collection service, where there is no initial letting fee, and you are effectively spreading the cost over the period of the tenancy, where we're collecting the rent for you as well, and obviously keeping those records. You'll be able to sort of get rent guarantee on top of that. Our gold service is our full management service, where we look after everything throughout the tenancy. So we'll do the property inspections, deal with all your maintenance, check in, check out, and sort of a full package there, where a landlord doesn't need to have that sort of direct involvement, but can stay obviously involved as far as we're concerned, and we can keep you informed of any changes, and all that advice is there as well. And then we are now able to offer our platinum service, which will include rent guarantee and legal protection insurance. So we have a sort of a master umbrella policy with the Lettings Hub, who provide our references and insurances for us. whereby we are able to add landlords and properties to underneath that, into that sort of that master policy, and provide rent guarantee and legal protection insurance there. And that sort of is all part of that service, as included there as well. So if you need any information on any of these services, then please contact me. I will. I'll give you my email address now. Didn't include it on this slide. Sorry, it's d.clark@nockdeighton.co.uk. I will be sending out copies of these slides to all those that have registered, so that will come from my email address as well. And going to just jump onto any questions at this point, and I will stop recording.